Good morning. I think it's still morning, and may it please the court. Lucas Vebber, appearing on behalf of Wisconsin Manufacturers and Commerce Incorporated, the other plaintiff and respondent in this matter. I'd like to begin by talking, briefly just following up on Justice Protasevich's question with regard to where that rulemaking requirement is. That rulemaking requirement is in 227. It exists in both 227.10 sub 1 as well as in the definition of a rule in 227.01.13. The agency, the department, or the legislature doesn't always impose a rulemaking requirement when they intend for the agency to promulgate rules. We see that even within Chapter 292. Under Chapter 292.31, subsection 1, the DNR is required to promulgate a database of all hazardous substance locations. The legislature recognized that that might be a rule. They then exempted them from rulemaking explicitly. They said in subdivision 4 there that notwithstanding sections 227.01.13 and notwithstanding sections 227.10 sub 1, that database is not a rule. So I think the legislature has recognized that those two sections of the statutes do apply in places where they haven't directed an agency to promulgate rules. Certainly the legislature has commanded that agencies shall promulgate rules in particular cases, but they haven't always required it. And I think that's helpful background here as we go on to the other issue that's in this case, and that's the department's interim decision as it relates to their administration of the Voluntary Party Liability Exemption Program, or the VPLE program.
Counsel, before you get to that, your comments addressed in part now 227.10. Do you agree with your opposing counsel's comment that the posture of your argument has changed in this case from that advanced in the Court of Appeals by making a more, what he suggests, aggressive push on 227.10 sub 1?
Your Honor, I think we've always argued throughout this case that it requires rulemaking, and the source of that requirement comes from 227.10, but it also comes from the definition of a rule in 227.
My question is, do you agree with his assertion that your position has changed from the Court of Appeals, where you were advancing arguments vis-a-vis the website and the letter, among others, that now your emphasis here is an aggressive attack under 227.10? Do you agree with his assertion that there's a change?
Well, no, Your Honor, and I think we're still relying on those letters and the website as evidence of the department's policy that they've adopted here. So the policy is not the letter itself. The policy is the department has a policy that's evidenced by the letter, but it's the policy the department has adopted that was challenged in this action.
It wasn't clear to me ultimately what the response was, so let me ask you this question. Do you agree with your opposing counsel's assertion that there is no dispute that PFAS satisfies the definition of hazardous material?
No, I don't agree with that, but I think the appropriate way for the agency to make that determination is to promulgate it as a rule. And to my colleague's point, that if it's something that is almost, if it's much easier, if everyone agrees, if it's a standard that very clearly will apply here, then that's certainly where the standard should be drawn in the statute. I would also say that the agency doesn't need to promulgate and list every single substance it can. It could also do what federal law has done and list objective criteria for what could meet the statute. That's another way that they could comply with the requirements under 292. The VPLE interim decision, which is the other issue in this case, relates to the state's brownfield redevelopment program. So the VPLE program allows sites to be remediated, redeveloped, brought back into the stream of commerce. It's a major benefit to the state, local communities, and the public at large. Typically, when there's a discharge of a hazardous substance, that hazardous substance is remediated. Once it's remediated to the department's satisfaction, they issue a case closure letter and everyone moves on. What the VPLE program does is it goes above and beyond that. The VPLE program is a voluntary program that parties can apply to. Once they're in the program, once they've been accepted by the department, they conduct a much broader investigation. They look for any possible hazardous substance discharges that they were not previously aware of. They remediate all of those substances, and then the department issues what's called a certificate of completion.
Which has the benefit to the property owner, right? So in addition to the other people you listed, it has a significant advantage to them, correct?
Yes, a significant benefit to the property owner. And the benefit is that it gets a clean bill of health. The property owner has remediated that site, the department's satisfaction. Once the department is satisfied, they say, hey, we don't believe there are any hazardous substances on the site. It then shifts liability from that property owner to the state if a legacy discharge is found later on the site. Of course, future discharges of hazardous substances are not covered by that. The interim decision policy upended the VPLE program. The interim decision was made to completely eliminate the issuance of those general certificates of completion. Fortunately, for landowners who want to rely on the VPLE program, that interim decision is unlawful. And it's unlawful because it meets the definition of a rule under 227.01.13. This court, in Citizens for Sensible Zoning, has broken down the definition of a rule in 227.01.13 into a 5-part test. A rule is a regulation, standard, statement of policy, or general order of general application having the effect of law issued by an agency to implement, interpret, or make specific legislation that is enforced or administered by that agency. Where an agency action meets that 5-part test, it is a rule, and it is required to be promulgated under Chapter 227. Here, the interim decision, as I said, meets that definition of a rule. First, it's a regulation, standard, statement of policy, or general order. It announces the department's policy to all VPLE program participants, indeed to all Wisconsinites, that it was not going to do something in particular, it was not going to issue.
Do you have a right to participate in the VPLE?
It's a voluntary program that you have to apply for.
Right, so you have no real legal interest in it, right? I mean, the department could just decide that they're not going to grant any of these.
Yes, they've made a general policy that they're not going to grant any of them. That's correct. And that general policy is a rule that they would have had to promulgate because it governs their enforcement and administration of that
No, I'm
program.
saying in theory they don't have to give it to anybody. You don't have a right to come to court and say I'm entitled to a VPLE.
Correct. They do not. But once the department makes a general policy that they're going to apply to everybody who applies in that program, with the VPLE program, the department has broad discretion. They have discretion on how to run the program, how it operates. But once the department makes a uniform policy as to how they're going to exercise that discretion, that they're going to apply to everyone, that's a rule. It's a general policy of general application. It has the force of law. It was issued by an agency to make specific legislation that's enforced or administered by the agency. That's why the interim decision meets the definition of a rule. It was not promulgated as a rule, and it's unlawful. As I said,
I still don't see how you have an interest that could be legally affected. If you have no interest in having it in the first place, how do you have an interest that's legally affected?
Well, our members rely greatly on the VPLE program. It's a tremendous program.
Because it's a tremendous program that helps you, but you have no right to it.
It certainly helps us, and it's certainly available to our members. Generally it was, anyways, prior to the interim decision. The interim decision took the value away from that program. They couldn't apply for it. Why would they? There was no benefit to them. And the reason that there was no benefit to them, the benefit that was available potentially to them, was taken away by the department's rule. As I was saying, it's generally applicable. To be generally applicable, it need not apply to all persons within the state. It just has to apply to a class that people could be added to. Certainly here it applies to all VPLE program participants, of which, as I said, anybody could apply to join. And third, and there's been a lot of discussion here on the force of law. That's the third element of the 227.01.13 test. The interim decision certainly here has the force of law. Case law indicates that an agency action has the effect of law for two reasons, which are applicable here. When licensure can be denied, or when the interest of individuals in a class can be legally affected through an action. And that's exactly what the interim decision here
So
does.
we're back to that. Individual interests of individuals can be affected. What interest do your clients have in participating in the VPLE law?
Well, generally they could apply for the program.
They can apply and they can be rejected. So what's their interest? They don't have a right under the statute to have it, right?
No, but they have the right to apply to the program and for the program to exist.
Okay, so they have the right to apply, so that's what you're saying the interest is?
Yeah, and once the decision is made by the department that they're going to, again, universally apply that policy to all applicants to the program, which they did here, The agency has adopted a policy. They've adopted a rule. Once an agency adopts a policy, they're engaging in lawmaking. That's a legislative function. They have to exercise that policy according to the confines of Chapter 227. If an agency adopts an unlawful rule, it has unlawfully usurped the power of the legislature, and our Constitution doesn't allow that.
Counsel, could you respond to just the argument of your opposing counsel that, just going back to the force of law question?
Yeah.
I understand when, there's lots of statutes that give the executive branch discretion to do A, B, or C. And that happens all the time. And so, Governor Walker might have done A, and then Governor Evers might do B, more often or less often. And maybe they say it, maybe they don't. But those are generally understood in the law to be within the prerogative of the executive and exercising the discretion given to them, if that's what the statute does. So the argument your opposing counsel is that it's not a force of law question. It's just how you exercise the discretion that you're already given by the law. How would you respond to that?
Yeah, I would respond to that by saying the department here is characterizing all of these actions as guidance documents that don't have the force of law. I think the primary difference between a guidance document and a rule is that rules have the force of law, guidance documents do not. So certainly when the executive is administering a statute that's plain and clear, tells the executive exactly what they need to do, the executive is going to take those actions, and there's no adoption of a statement of policy, or there's no adoption of an interpretation of the statute that's needed here. They just take the steps that they're commanded. Once the executive, though, goes a step further, as here, I think the hazardous substance definition is a perfect example of this. It's a broad, open-ended definition of the statute that clearly contemplates that at some point uncertain in the future, yet unknown substances may become regulated by that statute. The problem is nobody knows when that point uncertain is known. The department says, oh, the science has evolved to the point that it is. But how does everybody know? Because for 50 years it's been operated successfully, as they said, but during those 50 years, PFAS were discharged and nobody thought they were hazardous substances. So at what point do people know, or are they supposed to know, that those substances become hazardous? And the answer is that once the department makes that determination, they have to promulgate that as a rule. And that gives the fair notice to the regulated community, but it also is their constitutional duty when they're exercising their policymaking power.
So are you saying this, are you making some kind of due process claim here? That they had a duty to fair notice? I mean, that seems to me you didn't make that argument.
In our brief, Your Honor, we argued our understanding of how the statute works, and we responded to their argument by saying that, if the statute doesn't work this way and it allows the department to regulate on an ad hoc basis without promulgating rules so that nobody knows what the law is as they're doing that, then that would raise constitutional concerns, due process concerns. Yes.
I thought your argument,
pretty high
I
burden.
heard you adopting more of the ambiguity argument of Leatherridge.
And
Go ahead.
Yeah,
you know what I'm going to ask.
I think it goes hand in hand. Those two arguments are related, Your Honor. I think the milk example is a great example here. The department has said that if a tanker truck of milk spills, it is certainly a hazardous substance discharge. But today he said if you drop a gallon of milk, it's not a hazardous substance discharge. So somewhere in the middle there, it becomes a hazardous substance discharge. But when? Nobody knows.
Well, how would they ever function? Each individual case is going to be different. Every fact situation is different. What if they spill 5 gallons? What if they spill 10? What if they spill 20?
What if it's soy milk?
What about soy
Exactly.
milk? What about almond milk? What about oat milk? That's my favorite.
Your Honor,
That's a whole nother debate.
Exactly,
But my
Your
point
Honor.
is these are
Exactly.
fact-specific situations. Isn't that exactly why we have enforcement actions? Isn't that exactly why we have the ability to interpret that the executive has to be able to apply the law? That's called applying the law to the facts.
Yeah, Your Honor, exactly. And I think that, to your point, it does create a significant amount of uncertainty. I mean, where do we draw the line? If a milk delivery truck has a hand truck full of milk crates and they bring it in and spill it, does that rise to the level of hazard?
Well, right, but
Nobody
what
knows
you're
when it's
arguing
gonna
to us and what
meet that.
Attorney Brewer's arguing to us is that somehow DNR has to set all this out in the statute or in the rule before they could possibly act. And that is insane. That
Yeah.
means that you can spill the 20 gallons because by the time you make a rule about it, heck, it'll already have done whatever damage it did.
Yeah, and Your Honor, that's what the statutes require. That's what 22710
So
sub 1
227
requires of
requires
DNR.
every single, so we got to say whether it's 1 gallon, 5 gallons, 10 gallons, 20 gallons, and then if it's 25 and we don't have a rule, we can't enforce it. That's what I hear you arguing, and that's what I hear Attorney Brewer.
Your Honor, as I said, I think the department could provide a list of substances. I think they could also promulgate objective, and I'm sorry, my light is on.
May continue.
They could also promulgate a list of objective criteria by which the public could, in each one of those circumstances, affirmatively know if they're violating the hazardous substance statute or not. That's what the federal government does. That's what the DNR could do, but they haven't done it and they refuse to do so. And we're asking this court to require that they do so. And for these reasons, I would ask that you affirm the Court of Appeals in this case.
Did we miss anyone up here?
Thank you, Chief.
Okay. All right. Thank you.
Thank you.
Counsel, in the interest of time, as you approach the podium, I'm going to